I'm not threatening you. Say one more word, and that's 30 days. 30 days.
Hey, what's going on, guys? Welcome back to Sovereign Citizens Hall of Fame with your boy TP. Today, yes, this is number 26 of our compilation video series of different videos that we've done in the past that were some classic moments. We are here today to share some more of those with you. Before I cover the judges' courtrooms that we will be in on today, let me just give you a little info. There will be no commentary at the end of this, and there will be chapters added to this video. With that being said, first, we will be in the courtroom of Judge Jennifer Grant out of the state of. Second, we will be in the courtroom of Judge Donald Chisholm, also out of the state of Michigan. Third, we will be in the courtroom of Judge David Ricke out of the state of Kansas. And last but not least, we will be in the courtroom of Judge John Kmetz out of the state of Michigan. Some classic moments here. I hope that you guys enjoy it. Don't forget to comment, subscribe, like, whatever it is you need to do to continue to help these videos go forward. It is much appreciated. But with that being said, guys, I'm getting ready to get out of here. So let's go ahead and jump into this compilation.
All right, the Devontae Richard matter 2A04000092 and 2A04000113. Richard, if you could activate your audio and video so I know that you are hearing. Okay, thank you. I wanted to make sure you were participating. Now, is this the case that I believe I saw recently? There was a eval set up and they were unable to reach him to participate in that evaluation.
That's my understanding, Your Honor. I saw that as well. I think the last time we were in court, counsel indicated that the meeting had been set up to do the evaluation and the date was discussed. And it looks like Mr. Richard did not appear for that.
And for the record, Sean Parent for Mr. Richard. Yes, unfortunately, that appears to be the case. I'm not sure why Mr. Richard didn't appear at the evaluation.
So, Mr. Richard, we've been waiting for you to talk to one of the doctors, and we've been setting this case over for that to happen. When you were here on April 8th, we discussed that you were scheduled for that appointment on April 24th. So I know that you were aware that they had you calendared. Mr. Richard, why didn't you show up for that appointment?
Well, that was an assumption. I wasn't aware of anything.
Well, you were at the hearing when we talked about it, so.
I don't recall.
You participated on Zoom on April 8th, and we discussed that your evaluation was calendared for the 24th of April.
Was there anything signed for confirmation?
Your attorney has been working to get that set up. So.
Well, I haven't talked to anybody.
Mr. Parent, have you been in contact with Mr. Richard?
Looks like my office, we tried to reach him to make sure that he appeared at the evaluation, but we were unsuccessful in reaching him.
Do you have proof of that?
Yes, I have my colleague's notes that we tried to get a hold of you.
And what was the number?
I'll tell you in just a moment.
Yes.
Mr. Basler, you are excused. Thank you so much for your help this morning.
You're welcome. Bye-bye.
So, Mr. Richard, we have the phone number that ends in 1752.
I'm talking about the number you supposedly contacted the defendant on.
Yeah, you're the defendant, and it's the phone number that ends in 1752.
That's an assumption and presumption. I'm not nobody's defendant. I'm authorized representative of that account.
Okay, so Mr. Richard, the thing is, if you cannot participate out of custody, the court may have to set bail and have you placed in custody to get this evaluation accomplished. So when you are informed of the appointment and then you choose not to appear, the court interprets that as a willful violation.
Under what law are you saying that I could, what charges, what are the charges?
We've gone over that. You have been told that you are charged with driving while license suspended and driving without an ignition interlock device. So I understand you disagree, but at this point, we need to.
I don't disagree with none of the facts. I said, what was the date?
The date of the driving? Is that what you're asking?
Well, I don't drive, so I'm trying to figure out the date you have on file.
June 4th, 2022, Your Honor, is the charge date.
Thank you.
Okay, and have I been charged with anything?
Yes.
And what is it? What are the charges?
As the court just read aloud, driving while license suspended and driving without a functioning ignition interlock.
And is there a witness that you can bring to attain to that?
Those are the criminal charges. You also were cited for not having insurance.
Yeah, but do you have a witness?
Yes, the city has witnesses. We have the officer that will be testifying.
The officer. Okay, well, can you read the police ticket on the record?
We're not having a trial today. We're trying to figure out whether or not you are competent and able to proceed in this matter, and that requires that you speak to a doctor. But that is what we're trying to accomplish. And Mr. Richard, if you refuse.
Can you explain to me? I don't understand. So can you explain to me how
we've explained this to you previously. So what I'm going to ask you is whether or not you are going to comply with meeting the doctor out of jail, or does the court need to set bail and have you booked into custody so they can talk to you there? That's not what I'm wanting to do. I would like you to cooperate and have this case proceed with you out of custody.
Well, I need some type of contract to obtain to whatever you're asking, because I have questions and you're not answering them. Are you willfully not answering any questions?
Your Honor, at this point, I think given the track record of Mr. Richard and his unwillingness to comply, the city is going to be asking that the court set bail and remand him on that bail to have the evaluation done in custody.
Mr. Richard, can you assure the court that you will come to an out of custody evaluation?
I will agree to anything if you guys can tell me the nature and cause of this action. My Sixth Amendment right. I need to know these things before we can move further. Are you refusing to tell me?
I didn't quite hear your question. What are you asking?
I need to know the nature and cause of this action. I need to know that before we can move forward.
Yeah, I believe that the court has told you that you're being charged with driving a license suspended in the 3rd degree and operating a motor vehicle without an ignition interlock device.
Okay, well, I have a question for the judge.
What's that,
Hello?
Mr. Richard?
Hello?
Mr. Richard?
Hello? Or can you hear me?
Yes, I can hear you. You should sit down, and then instead of having me facing you at the clouds, you should participate in this hearing. Thank you. So every time we have a hearing, you ask these same questions, and we've explained to you that you're facing criminal charges and that we need to have the doctor speak to you. And so right now, your option is whether or not, as your attorney said, you can agree to meet with the doctors and stay out of jail to do that, or the court will have to remand you into custody. so that they can
So
talk to you
basically,
while
you're
you're
telling
in
me you're
jail.
refusing to answer me. You're refusing to answer any questions? That's what you're saying? Because I just have questions.
All right, does
Hello?
not. Mr. Richard? We've answered your questions. We're going to proceed at this point. I'm going to.
I didn't even answer. I didn't even ask the question. So how did you answer it? That's what I'm saying. Are you refusing to answer the questions?
What do you want to know besides what you're charged with? What was your other questions?
My other question was, did you or did you not take an oath to uphold the Constitution? Can I just get a yes or no?
That would be a yes.
So you're enforcing statutes right now, and so you're totally going against your oath. So I'm trying to figure out what authority do you have to tell me to do anything as a public servant? Can you answer that question, please?
Mr. Richard, I am authorized by the revised Code of Washington to sit in this court. I'm duly appointed to be a municipal court judge. I've taken my oath. You're charged with a violation
If you
of
took
the
an oath,
RCW and the Lake
if
Forest
you took
Park
an oath, then
Municipal Code.
why are you enforcing statutes if you took an oath to uphold the Constitution?
I know you don't think that it applies to you, but it does. So
I didn't say it didn't apply to me.
I'm going to set bail in this matter at
You're making
$10,000.
assumptions, ma'am. You're making assumptions, ma'am. I never said it didn't apply to me. But we both know here that the Constitution is not for me. It is for the public servants. So I don't know why you're making assumptions and presumptions. All I had was questions, and you're just going around me.
So, Mr.
Obfuscation
Parent,
is
I'm
a
going
big
to
thing
set
now.
bail at $10,000, and we're going to end this hearing, Mr. Richard. You can report to jail. You can come in, but we are trying to do this without you having to be in custody, but you are refusing to cooperate.
I didn't refuse anything. I was never put on notice, so I didn't refuse anything.
Oh,
Everything you're doing
I know
right
you
now
were
is
put
because
on
you want to
notice
do
at
it.
our last hearing, so that's on the record. So
What's
I
on the
know that
record?
to be false, Mr. Richard. So that
So
is the status of this case.
everything that I asked you, am I wrong? Is that
Yes,
what you're saying?
yes, you're wrong. So we're
I'm
going to
wrong.
this and we are done on this matter. Mr. Parent, if he does reach out to you and something can be arranged for them, but right now the doctors have tried twice to contact you and you've taken a spot that would have been available to someone else. So we need to progress this matter and that bail will be set and we'll continue with an in-custody hearing date when you are booked. A warrant will be issued.
And upon the booking, Your Honor, would the court consider amending the competency evaluation order to reflect in custody, just to kind of expedite that process?
Yes.
For the record, the judge is willingly going against public policy. So on here and in, you're held liable for everything you do from here on out.
All right. Thank you, Mr. Richard.
For the record.
I get the impression that he may be filing a special appearance on behalf of a sovereign citizen.
Ducky. Okay, we've got Mr. Myrick back. This is 25-00183. People of the City of Berkeley versus Kamash Daku Myrick.
Magistrate, I'm just going to acknowledge my presence for the record. Patrick Gagnick. I'm here as appointed counsel on behalf of the arraignment docket this morning. I did speak to Mr. Myrick in private. I did explain to him he does have the right to counsel. I explained to him, obviously, that right. He's indicated to me unequivocally that he does not want counsel. Mr. Myrick, is that a fair statement?
That is a fair statement.
So with that said, I'm here and present, but with that, I believe Mr. Myrick will address the court on his own behalf.
Mr. Myrick, you have the right to decline counsel. You also have the right to change your mind. If you do, just notify the court.
Yes, sir.
You've been charged In this citation that was issued on the 22nd day of January at about 5:58 in the morning, with driving in the city of Berkeley on Henley near Franklin Street while your license to do so was suspended. Driving on a suspended license is a crime for which you could be incarcerated up to 93 days and or fined $500. You have a right to a trial. Trial can be before a judge or a jury. You can act as your own attorney or you can be represented by counsel. If you cannot afford to retain your own attorney, an attorney can be appointed for you. You'd have the right to confront and cross-examine the witnesses against you. You'd have the right to testify yourself or not to testify. In the event that you choose not to testify, your silence cannot be used against you. You have the right to be presumed innocent until you're proven guilty beyond a reasonable doubt. The court's going to enter a plea of not guilty on your behalf.
No, sir. I don't even understand the charges here.
The charge is driving a car on the streets of the city of Berkeley while you're not licensed. You're suspended. That's the allegation.
Well, I totally understand, and I would love to plead, Your Honor. But before I have some questions on the record before moving forward and concerning the subject matter of the jurisdiction and the nature and cause of the action that's brought against me.
The nature of the cause brought against you is a criminal charge.
Okay.
Alleging that you were operating a motor vehicle on the streets of the city of Berkeley while your driver's license was suspended by the Michigan Secretary of State. That is the nature of the charges brought against you.
Thank you, Your Honor. For the record, are you saying that these are criminal charges?
Yeah.
Okay, Your Honor. Further, that brings a little bit more confusion for me because under the Constitution, there are two criminal jurisdictions. One is under the common law, and the other one is under admiralty, and that's a military tribunal venue. And under Article 1, Section 8, Clause 17. Which one of these criminal jurisdictions am I being brought on charges under?
Mr. Myrick, your perception as to the nature of the Constitution and its implications is grossly distorted. You're not dealing with reality.
Objection, Your Honor.
You can object all day long, but the bottom line is that what you are alleged with doing is a crime, and you can face you are facing criminal prosecution here with a potential jail sentence of 93 days. Now, this isn't complicated. If you want to come up with words that don't make sense, keep talking. But the bottom line is that there's no correlation with what's going on here and admiralty law whatsoever. And the common law is a civil concept. We have statutes in the state of Michigan, as do all 50 of the states. The federal courts have statutes, and common law is a civil thing. There's no common law crimes.
Exactly. So you've ruled out the common law, Your Honor. So the other criminal jurisdiction that I can be brought in charges under is under admiralty, and that is a military tribunal.
There is no basis in law or fact for the conclusion that you stated, sir.
Your Honor, you said that I'm under a criminal. This is a criminal charge, correct?
Yeah.
So which of the two criminal jurisdictions?
You haven't heard what I've said, sir. This is not a matter of having the two choices that you have spoken to.
Wow.
You are misreading the Constitution of the United States, the Constitution of the state of Michigan, and the statutes that are brought against you here. There's nothing to do with admiralty. You weren't in a boat.
Well, Your Honor, you two have a sworn oath of office, correct?
I am sworn to uphold the Constitution of the United States, the Constitution of the state of Michigan, and the statutes related thereto. And that means that I'm not going to.
So you do have a Sixth Amendment obligation to inform me of what jurisdiction.
And I think I have done that. I have told you that the people of the city of Berkeley have brought charges against you.
Well, Your Honor, the people is not a person. If I'm being brought up under criminal charges, there needs to be a corpus delicti, which there isn't. So I'm asking you.
Do you know any other legal words? Why don't you just mix and match them here?
Well,
maybe you could get a Department of Labor form and read a couple lines of that into this record too. Or maybe you'd like to deal with the probate code. But the reality, sir, is that you've been charged with a city ordinance violation. It's clear what the ordinance says. It's clear what you've been charged with. You have a right to be presumed innocent, and you have a right to a trial. We're going to set this for a pre-trial before the trial. You'll be notified by mail. Do you still live on Mendota?
I do, but I have
What is your phone number?
I'm not issued a plea, Your Honor.
I have entered a plea of not guilty on your behalf.
I object.
What is your phone number?
You cannot enter a plea. I do not. I have not entered a plea.
I just did.
Your Honor.
What is your phone number?
There is no plea that you can put enter in because I didn't voluntarily enter in the plea, Your Honor. I'm asking you, Your Honor.
You want me to enter a plea of guilty?
Under the two jurisdictions that
there's not two jurisdictions.
There's only two jurisdictions that I can be charged under the Constitution,
no, that's
Your Honor.
Mr. Myrick. That's what your conclusion that there's only two jurisdictions here is absolutely without merit.
Your Honor, you said that this is a criminal charge. I'm asking you, Your Honor.
I'm asking you what your phone number is. Let's get down to basics here. You're making this very hard on yourself.
Your Honor, I
What's
have
your
the
phone
right
number?
to assert my right, Your Honor. And
What
I am
is your
asking
phone
you,
number?
Your Honor.
What is your phone number?
My phone number, Your Honor, is.
Yes, I'd like to know it.
Your Honor, we haven't even established what jurisdiction we're in.
I have established that. I told you it's the people of the city of Berkeley that brought the charges against you.
Your Honor,
you said that three times now.
You stated on the record that these were criminal charges, Your Honor. I need to have an understanding. By the Constitution, Your Honor, there are only two criminal charges.
Where does the Constitution say you have to have an understanding?
Say again, Your Honor?
Where does the Constitution say you have to have an understanding?
By the Sixth Amendment, Your Honor. The
Sixth Amendment says you have to understand. The Sixth Amendment can't make you understand if you're being unreasonable.
But, Your Honor, I have the right to understand what jurisdiction that I'm being brought under, and you have an obligation to inform me of that jurisdiction, Your Honor.
Which I have done about 17 times.
By the Constitution, under Article 1, Section 8, Clause 17, Your Honor.
Mr. Myrick, your bond is $1,000 cash or surety. It must be paid within 48 hours or there'll be a warrant issued for your arrest.
Your Honor.
That's done. We're through. Good luck.
Your Honor.
Get your own lawyer.
Your Honor, you have not given me a jurisdiction, Your Honor.
I've given you a jurisdiction 4 times. I'm not going to waste any more time.
Your Honor, I think you there was a disconnection or something.
No, I disconnected you. If you want to continue, come to the courthouse, sir.
Your Honor.
Come to the courthouse if you want to continue the conversation.
I would like to move for dismissal.
I would like. It's not going to be. No.
I would like to move.
You're gone.
She's a beauty for chocolate. Oh my God. Oh, we're recording at this rate.
Okay, why is there a Juan Flores on this meeting? There's no response. Okay, whoever's Juan Flores's box is muted, so I'm not hearing anything. They can unmute themselves if they've got some business with this court.
Hi, Judge. I am Counselor Flores, and I am resident McLaughlin's counselor, and they have him here right now.
Okay, very good. Thank you.
Yep.
Jesse Travis McLaughlin.
Yeah.
It's the state of Kansas versus Jesse Travis McLaughlin. It's case number 2024 CR 397. Mr. McLaughlin appears from a Hutchinson Correctional Facility Zoom location. Brett Sweeney appears for the state of Kansas. Mr. McLaughlin, I have before me a charge of battery against a law enforcement officer, a level 5 person felony. Since a felony is involved, you will not be asked to plead at this time. Rather, a preliminary hearing scheduling will be made before your assigned judge, which is the Honorable Jan Satterfield. Judge Satterfield's next docket for that purpose would be April 7, 2025, 2:30 p.m. You must fully participate by Zoom in Judge Satterfield's docket at that time, April 7, 2:30 p.m. I trust, Mr. McLaughlin, that you, being in prison, don't have the financial resources to hire your own lawyer.
That's all right. I can represent myself.
Okay, well, you can take that request up with Judge Satterfield. At this point,
Every
in
man
the
must
abundance
speak
of
for
caution,
himself, Your
I will
Honor.
appoint a lawyer, and then you can, before Judge Satterfield, properly conduct a proceeding if you really do want to
Point
represent.
of order. What gives you jurisdiction to appoint a lawyer over me?
I have statutory authority to do so. So, Mr.
So
Kaufman,
what
I'm
gives
going to
you
appoint a lawyer at this
what
point.
gives you jurisdiction over me? You must establish jurisprudence as a point of order.
I'm not going to play your sovereign citizen gibberish game.
I'm not a sovereign citizen, sir.
All
I'm not
right.
a sovereign citizen.
You sound like one.
Well, I'm not.
All right. I assure you I have jurisdiction. So we've got a court date set before Judge Satterfield. I'm going to appoint James Watts at this point to represent Mr. McLaughlin, noting he's made a request to represent himself. Again, that's to be a matter taken up fully before the assigned judge, Satterfield, at the hearing date on April 7 at 2:30 or some later time. And the court will set a $5,000 cash or professional surety bond, though obviously it's not going to affect his current incarcerated status. All right, bond set, attorney appointed, court date established on Judge Satterfield's calendar. Anything else we need to address at this time, Mr. Sweeney?
No, Your Honor.
Mr. McLaughlin? Apparently not.
Yeah, you need to address the point of order. As a
I've
first
addressed
point of
all of
order
the
in
points
court
of order
the
that I'm
first
inclined
thing
to address
you must
today.
do is establish
Mr.
your
McLaughlin.
jurisdiction.
The McLaughlin matter is currently in recess, and we'll move on to another matter on the docket.
I object to moving on in any manner.
Objection noted and overruled, Mr. McLaughlin. All right, let's move
Request
on.
a copy of.
Then.
I
Thank
request
you
a
to
copy
the
of the
Hutchinson
minutes,
Correctional Facility.
transcripts, these proceedings.
We can go ahead and take him off the meeting at this time.
I'm wondering if you got those check stubs that I've entered in.
I didn't get any check stubs.
So
Oh yeah. Wait a minute. I did get some check stubs. Yes, you were the one that did have them. Yeah, I had a question on those because you got 2 support notices on each stub. So do you have more than one case?
yes, sir.
Okay, how many children do you have?
2.
Okay, this one and another one?
Yep.
Okay, because I was trying to figure out, I have a feeling that what's happening is they are maxed out on how much they can take out of your checks. The reason that you keep getting hauled in is because you're not paying the full amount of child support.
But at the time that they was taking the money out of my checks, they
Right.
issued the warrant.
Right. If you owe
And-
$100 and they only collect 70, you're gaining $30 a month in arrears. And once the
No.
arrears hit a month, well, that's why I was asking, because the amount of child
Those-
support that is are these weekly checks or monthly?
Weekly, sir. It's
Okay.
440. It was receiving that. And at the
And
time,
how much did they say that you owe?
just now recently,
Yeah.
they said I was in arrears 5,000.
Okay. Yeah, because I have a feeling that's what's happening. Now
But-
you have the right to have this child support reviewed at this point in time. It's been 3 years since the last order, so it can be reviewed for you.
But my whole thing is, I wasn't paying because last year, April,
Mhm.
they got a $5,000 check on my behalf
From whom?
from an employer, from a settlement, which was from an employer.
Okay, and they confiscated all 5,000?
Yep, it was.
Okay, and that should have gone against any arrears. Now their next question would be, are you sure they got it?
Child support?
No, the $5,000 check.
Child support got that $5,000 check.
Are you sure they got it?
Yes, I'm sure they got it.
Because what I would do if I were you is ask for an accounting of the case to make sure they got it. An accounting will give you a computer readout of every month that you owe and every payment that's been made. And they do it in writing. So if you write them and ask for an accounting of your child support, because some of this stuff will not be in the court file. The court file is a public file. So the court does not know how much your arrearage is unless they apply for a show cause. Okay.
Okay. And I haven't been paying recently because I was under the impression that the obligation is $445 a month.
Well, it looks like how have you not been paying? Are you not employed anymore?
I'm at work right now.
Okay, well, it's because the employer automatically takes it out.
Right. I just started this job, and
Okay, then you have to notify the front of the court what job you changed to, so that they can apply it to the appropriate. Because they issue an automatic income withholding order. Again, that does not go in the court file because it contains some very specific information about you, and you don't want that public information.
This is what I'm trying to say to you, sir.
Hmm?
They received $5,000 last
And I told you what to do to deal with that.
April.
Yeah.
I was under the impression covered the rest of the year. I did not know that they.
No, they don't cover anything forward. They only cover things currently owed.
Right. Okay.
They can't hold money forward. If they have an overpayment within 48 hours, they will send you back a check for the overpayment.
Okay. Well, they still was in breach of contract.
There is no contract. This is the law. That's not a contract.
Is this
They're
Zoom
following-
just about child support?
Yeah. Sorry, Ms. Cry. That's what his motion's about.
And
So-
why did I have to join? I'm thinking this for
Well,
my
because
motion.
you have a motion.
Yes, I do.
I have a motion for child support and an amended motion for child support. Those are the only motions before the court.
My motion wasn't about child support.
What was your motion about?
It was basically just for me trying to get his rights and stuff revoked. I did all this
We
stuff.
we don't revoke rights in a parent in a family law case.
You should have been getting some paper. I did all this stuff.
Well,
last week.
that motion would be automatically denied because we do not revoke parental rights in a family law case. That has to be done in a neglect case,
In a what case?
an abuse neglect case.
So why did they have me filling out the papers?
I
And
have no
put
idea. I don't know what papers you filled out. I don't have them.
Mm.
Okay, so I'm sorry, I didn't know you had a motion. But I was going to ask for your input before we finish this. I'm just trying to deal with his issues on child support.
Okay.
He seems to be under a misapprehension that this is a contractual relationship, and it's not. It's a statutory relationship.
Okay.
The front of the court is following their statutory authority to collect child support on behalf of the child. So that's what's necessary, and they will automatically follow their rules and the statutes in doing so. The court tells them when or if child support should be reviewed. And again, I've informed you, sir, Mr. Miller, you have the right to ask for a child support review if that's what you're asking for. But yeah, if you're not paying support, they're going to be hauling you in to explain why you're not paying.
Well, I also was sick.
Okay, that's fine too. But again, you're going to have to explain why the payments weren't being made and why you owe.
Payments wasn't being made because I was under.
You're under a misapprehension, not an understanding. So That one I can tell you you're wrong on. So the best you can do is ask for an accounting to make sure that all money is accounted for and all payments are accounted for. Now, do you want this sent to the front of the court for a child support review?
I want this case closed and dismissed.
It's not going to be closed and it's not going to be dismissed.
So even though they were receiving the full monthly obligations, it's okay for them to.
If you owe, they're going to haul you in to find out why you're not paying the amount.
And we wasn't receiving I wasn't receiving no full amount.
Well, ma'am, part of this, you're not going to receive the full amount. You're on state aid. The reason that this case was brought, it was brought by the state of Michigan because of your state aid. When you're on state aid, the state mandates the child support be paid in accordance with the law, and then they confiscate portions of that child support to reimburse the state for what they're paying on behalf of the child.
Is this Admiralty Maritime Court law?
No, it's not Admiralty Maritime Court law. This is the state of Michigan. We are not in the middle of an ocean.
Because the flag in the back got a gold fringe on it.
Yeah, don't even do that bull. That's a bunch of bull.
You have
it is a United States. I don't know what you're receiving, ma'am, but this case was brought by the prosecutor's office on behalf of DHHS because of state aid involvement.
Oh, I don't receive anything. I haven't since
okay, well then once you stop that, then you should be receiving the full amount, but the state will confiscate part of anything that's still owed to them from any child support collected. Right now, I'm not sure how much the arrearage is. Obviously, there is an arrearage. So, no, the UCC, the Uniform Commercial Code, does not apply to this court, sir. This is a family law court.
That you don't have on the gown either, so you're not.
You're right. That's because I'm an appointed judicial official, not an elected judicial official. So yes, I have a full authority. I am sworn in. I am an attorney prior to being in my judicial capacity. So yeah, I have full authority, and the authority is given to me by statute as well. So I follow the statutes, the laws that I have to follow.
So this statutes and codes, it's not actually law.
It's not code. It's law. It's statutes. It's the laws of the state of Michigan.
Statutes and codes.
Statutes, no codes. The Uniform Commercial Code does not apply to this court.
Ouch.
All right. Do you want the child support review or not, sir?
I do want the child support review.
Okay. In that case, I will send this for a child support review. Ms. Cry, any questions, ma'am?
Nope.
All righty. I will look at your motion when I do receive it, ma'am. I don't know when it's scheduled for, but it was not scheduled for this morning. Okay.
That's what I thought this was for. Okay.
Yeah. No problem. This was for his motion.
Oh.
All right. All right. Have a good morning to both of you. I'll send this to the front of the court for child support review. Have your most recent current pay stub available. Both of you.
I'm under the impression that there's a warrant.
Yeah, you do have a warrant.
I didn't notice a warrant, but that wouldn't come up on this file for this motion. That would be a separate issue. You might want to call the warrant department if you believe there's a warrant, because you can deal with that.
I wasn't properly served on.
Again, the court has no paperwork concerning any of your warrant. I don't have her paperwork for her motion. I can't advise on things that I don't have before me because I need to look at them before to find out if they're properly served or not. Call the warrant office and find out what's going on if you believe there's a warrant. This is the first I've heard of it.
This is the motion for support.
This is the motion for support, and that's why I'm sending it to the front of the court for child support review.
And this all is under the same thing. Why they issued the warrant? Supposedly.
No, that's separate issues. This is ongoing support. Your warrant is about back support, if there is one. Okay. Yep. Two separate departments. All righty. Good luck. Have a good morning. Take care, everybody. Motion's granted for support.
I'm not threatening you. Say one more word and that's 30 days. 30 days.